this morning's docket. That is case number 105964 in the matter of the estate of Betty Jo Strader.
May it please the court, I'm David Troop. I represent Janet Prowley, the appellant in this matter that's on for review of the Court of Appeals decision admitting the will to probate. The appellant is one of the 5 adult children of the decedent. I'd like to reserve 3 minutes for rebuttal, if I may, Your Honor.
3 minutes is granted.
All right, thank you, Your Honor.
Did your client also object to the administration, to the intestate administration?
No, the administration was ongoing. We were 4 years into the administration when the will when the petition to probate the will was filed. There was a previous appeal that the Court of Appeals did reverse and remand because of issues that related to the administration. But no, she was not objecting to the administration, and that was before the will was discovered. This case is a very straightforward case, no real disputed facts of statutory construction, and it really turns upon the definition of one very common word. In KSA 59617, that provides that in order to pass property of a decedent by will, the petition to probate the will must be filed within 6 months of the decedent's date of death, except as hereinafter provided. Here, the petition to probate the will was filed some almost 4.5 years after the date of death, so it is barred by 59617 unless there is a hereinafter provided. The hereinafter provided that was found by the District Court and the Court of Appeals in this case is that in 59618. No one has suggested any other hereinafter proviso or bar or exception to 59617. It is our contention, appellant's contention, that 59618, the exception, applies only, the entire statute applies only to those wills that are knowingly withheld from probate and knowingly withheld by someone. This one was not. The District Court so found, the Court of Appeals so found, nobody's appealed that decision. So we have a will that was not knowingly withheld. It was simply lost in an attorney's office. That finding was made.
Can the knowing be constructive knowledge? I mean, because obviously it was in the office of the scrivener of the will, and that attorney knew that it had to be admitted, or should have known, within 6 months of death. Can that be constructive knowledge?
If I suppose, well, I don't think there's been a case holding that, and I think knowingly means you have to have knowledge that you have it. And here there was no claim or assertion that Mr. Brinegar's office was aware that the will was there.
Because someone slipped in the office and left it there without their knowledge?
I suppose that's theoretically possible, but I think my assumption is, and their assumption was, it got stuck in the wrong place.
Well, forgetting you have something is not the same as not knowing you have something, is it?
No, I think if you forget something, then you don't know it after you've forgotten it. The previous courts have held that 59618, where the first sentence, the title of it in the first sentence, clearly is limited to only those wills that are knowingly withheld. But the Court of Appeals held that the second sentence broadens that and applies to any will, whether it was knowingly withheld or whether it was not knowingly withheld, and basically any will at all. And one of the principal rules of statutory construction, there probably isn't a month goes by that this isn't in some case, is the legislature, when they use words of common understanding, that's what we use. We apply common definitions to words of common understanding. For the Court of Appeals decision to be, the majority Court of Appeals decision to be right, we must assume that when the legislature used the word such will to begin the second sentence, that what they really meant was any will. That they, and any is not a particularly esoteric word that has a whole lot of meanings. Such would seem to be a word, and in fact, according to the Merriam-Webster dictionary, dictionary definitions or common definitions of such are, in its adjectival form, it can be a noun or a verb, but as an adjective as it's used here, of the character, quality, or extent previously indicated or implied, or of the same class, type, or sort. In other words, if you're talking about such will, there has to be an antecedent. It's referring to something that you've just discussed. And what you had just discussed in sentence 1 of 59-618 was a will that had been knowingly withheld by someone and then was later discovered. Is it reasonable to infer that, as the Court of Appeals unquestionably did, or the majority did, that in the second sentence, the legislature intended such will to have a different meaning than such will did in the first sentence? And in fact, if you look, that's not the only place they used such in 59-618, because down when they're talking about the innocent beneficiary who discovers it, say such will may be admitted to probate as to any innocent beneficiary on petition for probate by any such beneficiary. When they use such beneficiary, does that only mean an innocent beneficiary that offers it within 90 days? Or does such there also mean any, so even the wrongful withholder could offer it? No, that's a ridiculous construction. And so if we apply normal definition to use of the word such, we have to assume that the legislature didn't mean any, but they meant the will of the type we've just talked about in the previous sentence. Recognizing that there were some problems, perhaps, with that reasoning, as Chief Judge Green pointed out in his dissent, and as he had certainly discussed in the Seth case that he wrote, the court went on to discuss public policy, and in deciding public policy, referred to this court's 1968 decision in N. Ray Harper's estate. Well, Harper's estate involved the opposite case. It involved a case where the beneficiaries got together within the 6 months, it might have been a year then, but within the statutory time period when a will could have been offered, and they reached an agreement not to offer it. And the executor stepped forward, petitioned to probate the will, and there this court held in a 4-3 decision, no, that's contrary to public policy to withhold a will from probate. The public policy is that all validly executed wills should be offered for probate. The Court of Appeals in this case took that, and in the Tracy case, took that statement out of context, and that shows the danger of taking a sentence out of the context in which it was made and applying it to a completely different set of facts. That's not the public policy of this state. The public policy of the state, as identified by the legislature, is set forth in 59-617, and that is that wills, if you want the will admitted to probate, you offer it within 6 months, and one exception, if it's knowingly withheld. The legislature has not spoken to create an exception for misplaced or lost wills. Certainly they could, but they haven't.
And what purposes are served by the public policy in 59-617, in your opinion?
The same type of purposes that are served by any statute of limitations. That it requires people to act promptly so that we don't litigate old, stale cases. The Tracy decision on its holding, finding that 59-617 was a statute of limitations, I have no argument with. I think that was a correct holding. And basically, like any other statute of limitations, and basically they said it has to be affirmatively pled. In Tracy, it wasn't, so the statute of limitations didn't apply. But we can have plenty of policy arguments as to the propriety of statutes of limitations generally. It's terribly unfair sometimes for somebody who's grievously injured in an automobile accident to find that for whatever reason their case got lost because it was filed too late. And there are cases with statutes of repose where sometimes you lose your cause of action before you know you have it. Those are policy decisions that are made across the street in the Capitol building. Here, the legislature made a policy decision, and this is also contrary to the Court of Appeals rationale or their identified public policy. If the public policy was that all wills be admitted to probate, why did the legislature, the period of time used to be a year in 59-617, then they lowered it to 9 months, and then they lowered it again to 6 months. So the legislature intentionally pulled some wills validly executed out of the universe of those that could be admitted. Basically, those that are offered between 6 months and 12 months used to be probatable, and now they're not, unless they were knowingly withheld. So the legislature over the years has shown a tendency to restrict the wills that are admitted to probate. Why they lowered it from a year to 9 months to 6 months, I don't know. I haven't found anything in the legislative history to suggest that. But the suggestion is they want probate cases over quicker than this. They want people to exercise diligence and go out and find a will. But we may not know why they did it, but we know they did it. And we can't assume they were asleep at the switch. 59-617's been amended, I think, 7 times since 1939 when it was originally enacted, and the only amendments relevant here are it keeps reducing the time. And so, but that is the public policy that's been set. If it is a desirable public policy to expand the proviso to include lost wills, misplaced wills, or something like that, then somebody needs to go over to the legislature and say, we need this statute amended. This is unfair to people, to beneficiaries of wills that get lost. That hasn't happened yet, and there's been 70 years to do it. I would also ask if that's the public policy, if the public policy is as broad as the Court of Appeals majority suggested it was, that all validly executed wills should be admitted to probate, then after the Pallister case, which was after the Harper case, and the Thompson case, both Court of Appeals cases where a validly executed will was denied probate because the petition was filed after the 6 months, why wasn't there any legislative action? Apparently the legislature thought that was an okay result, and nobody went to the legislature and said, hey, we got this terrible result, we need this law changed. The Court of Appeals seemed somehow favorably impressed that the legislature didn't do anything to undo the dicta in Tracy, but they didn't even mention, Judge Green did, but the majority didn't even mention why wasn't anything done about the results in Pallister and Thompson if in fact the public policy is what we're saying it is. And the fact of the matter is that's not what the legislature has said the public policy is. It's not all wills be admitted to probate, it's just those offered within.
Counselor, can I ask you an unrelated question here? This 85 will was referred to somewhere in the briefs as a mutual will.
Yes.
With her husband?
Yes.
Was there any argument that it was also a mutual or contractual will?
I didn't try the case, so I'm not sure I'm
But
competent to answer.
that is an exception also, wouldn't you say, that if you have a mutual and contractual will, it can be enforced as a contract outside the 6-month period?
And in fact, that was the situation in, I think it was the Pallister case. It was either Pallister or Thompson, and I apologize for not remembering which one. There was a claim that there was both a contract and
what I'm getting to is you said that you argued that there's only one possible exception, but depending on a factual finding of whether this was a contractual will, there's possibly another exception. Wouldn't you agree? If the court were to find that it was a contractual will.
Could be. I don't know whether there was that finding. I do know that that argument was not made.
Okay.
Either in district court or here.
Do we have any further questions of counsel? I see you're out of
Thank you.
time. Would you like 30 seconds to wrap up? Or do you think you've made your points?
If I get my 30 seconds to rebuttal, if I can have 30 seconds to respond to whatever they say.
I think you reserved 3 minutes.
Oh, okay. Oh, so I still have my 3 minutes. Okay. All right. That'll be fine.
Thank you.
Thank you.
Counsel?
May it please the court, I'm Joe Knopp, representing 2 of the 5 children. John McNish and I will be presenting our argument, and I've asked for 12 minutes of time and allow him 3 minutes to clean up whatever mess I've made. And if that's with the court's permission, I'd like to proceed.
That is fine. Thank you.
Today, we're asked to reconcile 3 court cases that the Court of Appeals has put down that counsel suggests are inconsistent. One is the Seth case. Marvel Seth was in Marion County, and her attorney, Ken McClintock, promised the beneficiaries that he would administer the will. He didn't do that. He didn't get it filed on time. And the Court of Appeals said, wait a minute, that falls within the exception. And the appellant here today admits that the Seth will should have been admitted outside the 6 months because of the misrepresentations and the negligence of the attorney. Now, in that case, the court did not find, I would argue, that there was a knowing and intentional effort to hurt or harm the beneficiaries. Mr. McClintock, I think, was dilatory, was negligent. He perhaps got overwhelmed with procrastination, and then after he didn't do it, he told his clients he had, which was worse. And he then appeared before this court again to be disbarred under the Code of Ethics, which said that he lacked diligence, he lacked competent representation, and he lacked communication with his client. But in none of those cases would it find that he knowingly and intentionally withheld the will in order to harm or create a positive outcome for somebody. Now that's the Seth case, and the Court of Appeals said that should be admitted to probate. Court of Appeals then had the Tracy case, and in the Tracy case, the will was sitting in the attorney's papers, and the attorney passes away, the attorney deceased, and the 6-month expires, and in the course of cleaning out his desk and his papers, he finds the will, and the court said, wait a minute, Court of Appeals said, that also falls under the exception in 617 because it was knowingly withheld by the attorney for the decedent. The third case is the Strader case, our case. In our case, the beneficiaries knew of the will. They knew that mom and dad had made a will. It wasn't joint and mutual, but it was identical wills that was made at the same time with Keith Sprouse. And for some reason, Keith took the original will of Betty Jo and put it in a box in his back offices that formerly had been, I think, part of their abstract company or something, but it was a safe kind of place, but wasn't then later used by the succeeding lawyers in the firm when Mr. Sprouse went on the bench, and it was misplaced. They're not aware of it. My client went to the law firm and said, do you have it? And they said no. They went to the bank, they went to the home, they looked everywhere for it. They said, well, then we'll go with intestate. And they proceeded under intestate. And then later, Mr. Branger found it.
They actually had copies of 2 different wills, didn't they?
Yes,
They had a 1996 will for which they had a copy. And was there any evidence of whether that had been executed?
I don't believe that there's any dispute that it had been executed.
The 96 will?
Correct. This
And
the
it
will that's in
had-
question now.
No, there was the 85 will was the one that was offered for probate, correct?
Okay.
And
No evidence of that.
okay, well, my problem is was there a finding on did anyone argue that the 96 will operated as a revocation of the 85? Was that argued?
No, it was not.
Okay.
It was not.
Counsel, can I go back to my understanding of how you characterized the Seth
Yes.
opinion? Did I understand you to say that there was no finding at either level of that court that there had been a knowingly withheld will from probate?
No, I think they interpreted Mr. McClintock's actions by not filing it as falling under that definition of knowingly withheld. But my argument is, I don't think that they went to the conclusion that he intentionally did it with the purpose of preventing the innocent beneficiary from benefiting under the will. It was purely negligence or inadvertence or procrastination that he did it.
But the court's holding, and I'm looking at the opinion, was, quote, here, the Marvel Seth will was indeed knowingly withheld from probation, thus triggering the potential allowance for a belated filing.
I'm not arguing with the conclusion. I'm arguing with the facts that led to that conclusion. That's the only thing I'm making the point.
So it had to have been an intentional withholding in order to be knowingly? Is that your position?
Well, that's going back to Justice Malone's question of what the standard for knowing is. And I think that's where we're coming back. If the court is saying that knowingly withholding requires a clear and present intent to do that, then that's one standard. Is there a constructive? I knew I had it. I was the bailee of this. It was a valuable document. I was entrusted to me, and I failed my fiduciary duty to provide that. Does that rise to the level of knowingly withhold? Does pure negligence rise to the level of knowingly withhold? Does what is the standard for arriving at knowingly withholding? And I think that's part of the clarification, because in this case, the court, in its opinion and in the transcript, the court was asked, did the Sprouse Brininger firm, did they knowingly withhold it? And the court said the court finds that no person knowingly withheld the will from probate, as such finding is not necessary as to an innocent beneficiary. We would argue that the trial court did not make a finding as to whether or not it was a knowingly withheld, because the court said that's not necessary under the Tracy case. And if the court wants to turn this case on that point alone, what is knowingly withheld, our request would be that it be sent back to the trial court for a final hearing on all the details that led up to that, and that you give the trial court guidance on what level of care is required. If it's a high standard, did they knowingly and intentionally withhold it for the purpose of benefiting somebody who would otherwise benefit? That's one standard. If it's knowingly withheld, says I had it, I took it back when I had it because I wanted to have the family come in and meet with me and potentially get the estate rather than have them take the will and go someplace else. So if I had the will in my possession, I have a higher duty to then produce it. And in all three of these cases, it was the attorney who failed to provide that will and failed to do it. The question you asked earlier, I'd like to address too. Why do we have a statute? Why is there a 6-month limit in 617? And I would suggest to the court that the purpose for that is to, like you say, to move the case along. I think the legislature gets a lot of, and the attorneys and the Bar Association gets a lot of blame for having estate cases go on, thinking lawyers are getting rich waiting for these cases to go out. So the legislature moved it up to 6 months, and the value of that is that at the end of 6 months, the court can begin to make decisions. We've got a valid will, or we don't have a will, we're going to sell property based upon the time having run. And if the will, even an innocent beneficiary's will, is not brought forward within that time and the property is sold and distributed, the statute says it's done. You can't come back and do that. So that's the danger of having the will sit there and stew. And so that's the value in the probate cases of the statute. Let me touch on legislative intent one moment and make a comment. The classic Will Rogers comment about those who respect the law and love sausage should not watch either one of them being made. The point I would make, Mark Twain, not Will Rogers, Mark Twain, I would argue that this is an area where the court can and should exercise more oversight. The Kansas tradition is a 60-day legislature, a 90-day legislature. The legislature meets in January to April, which just coincides with farmers' ability to get their harvest done, come serve, go home before the crops are planted. It's a citizen legislature. It's paid low, it has a limited staff, and it is creating a set of statutes that's 4 feet long. It's not a code, California code, that takes up walls and walls. And so the Kansas tradition is that the legislature sets things in place and the judiciary gives flesh to those words and those meanings. And that served the people of Kansas well. And there'll always be losers on either side who say the court is enacting or legislating, and that's the job of the legislature. But I would say that our historical tradition is that that's the way it works. And that kind of oversight is really needed in areas where the judiciary and lawyers have great insight. I think the probate code is one place for that. And in the Kansas tradition, the Judicial Council, the Kansas Judicial Council with judges and the chairman and vice chairman of the judiciary committees in both the House and the Senate and other lawyers meet to discuss these great issues. And the Kansas Bar Association has its legislative committee, and it discusses these issues. And so we have a great deal of input, not just the lawyers in the legislature, not just the interested people in the legislature, but everyone making that. And so my argument is, over the last 6 years, these 3 cases have been known to these bodies. And they are satisfied that this is the right outcome. This is the right intent of the entire probate code, which is to respect the will of the people. It strikes me that one of the greatest obligations we have as lawyers is to respect our clients, and certainly these cases put a bad faith look on lawyers. The Court of Appeals, and I'm not saying that the purpose of you is to protect lawyers, but the purpose of it is to ensure the confidence of the public in the judicial system. And these cases reassure people that the last words of a testator, the last words of a decedent are going to be respected.
How can we be sure if we don't know if the 1996 will exists, that a decision to go along with you actually supports Betty Jo's last wishes?
You know, that's a dilemma we always have in dealing with the uncertainty, and I can't do that. All I can do is with certainty know what we do have, and we do have a valid executed will, and that's what we're asking the court, rather than having it been handled by intestate succession.
So what happens if Betty Jo's 1996 will turns up next year? It's found in her closet somewhere, and it's the copy and an innocent beneficiary, and it gives someone $1 million. And an innocent, I want my $1 million. What happens then?
If under the logic that we're arguing, and I think it's the good public policy, because we want her last intentions known, that it would happen. Now, in the next year,
or 20 years from now.
But
where does this go? That's the point, I think, of the 6 months, isn't it?
Well, but if at the end of 6 months the land is sold and the property is distributed and there's no more assets in the estate, there's nothing for the will to act upon because it has already taken place. And so if a year from now another will is found, and we have gotten the real estate sold, and we've gotten and the well and drilling equipment all distributed out, and a final decision has been made, and the beneficiary is a BFP, a purchaser in good faith, then that will 20 years from now, 2 years from now, 5 years from now would have no effect on anything because they're left in the state to administer.
Counsel, before you sit down, if I understand your argument correctly, you would be asking us to find that the statutory term knowingly withheld is synonymous with carelessness. Carelessness is included in that term, is that right?
Yes, carelessness or even well, it'd have to be careless because I agree with you that if I am entrusted with anything of value, and certainly a will is, and I later I'm unable to produce it, then I have failed the standard of care, which would make me, I don't know, negligent or careless. Yes. So I would ask for a standard of care to be established that is whatever it is, if it's intentional or careless or something, a breach of fiduciary duty, whatever that standard would be.
But if you're doing something knowingly, is that consistent with also doing it carelessly? Aren't those mutually exclusive?
We're presumed to know the consequences of our actions. And so did I intentionally drive that car and cause the accident? So in that sense, I intentionally drove it. Was I negligent in failing to drive it under the proper care? Maybe not. So I guess that's the problem I'm having with answering that question.
So in this case, if the original will had been given to the client and the client stuck it in the fishing tackle box and
Yes.
forgot about it, and 10 years later appeared and said, oh, I forgot I had it, I hadn't gone fishing in 10 years, here's the will, it would be your position that that would meet the exception of the statute.
The problem in that case is whether or not that person is truly an innocent beneficiary at that time. You know, I guess that's to be the second definition, is does someone who has possession of it themselves and doesn't know it, are they at that point an innocent beneficiary? Or did they contribute to that delay in getting the will? And perhaps they're the sole person who's responsible for that because no one else knew they had it. So I wouldn't go so far as this. That's the group that I would put into the exception of the case. You know, if an attorney causes the problem and the innocent beneficiary was doing all they could with the attorneys, then those wills ought to be admitted. If the innocent beneficiary is the one who had the will and could be assumed to have been responsible for producing it, then whether they are an innocent beneficiary at that point or whether they are presumed to have knowingly withheld it doesn't make any difference because either one test they don't meet.
And the difference between that scenario and the facts in Strader is that here it was the attorney who carelessly
Correct.
had the will.
Correct. And my client, the clients directly went to the attorney and said, do you have it? And he assured them, no, we do not. Now, to the attorney's credit, when he found it, he said, I found it. The easy thing for him, unethical, but the easy thing would have been to put it in the shredder and pretend he didn't find it.
I didn't know I had it, but I knowingly withheld it.
I didn't know I had it, and I didn't
But
look
under
hard enough, and so by that I must have knowingly withheld it. I goes back to can we create a constructive bailment and hold him to a higher standard because it was a constructive bailment that requires him a higher duty than the duty of knowingly withholding.
All right, thank you.
I didn't hear you address the second sentence of 618. Do I take from that you would agree that a plain language reading of that is contrary to your position?
I think Mr. Troop makes a good argument. The problem is that that argument's been made 3 times, or at least twice. And the Court of Appeals in both cases have said that's not what that means. And we're relying upon the Court of Appeals and other judicial decisions to tell us what that word means.
Tracy being one case, and what's the other one?
That was the,
It's not Seth.
no, it's not Seth. It is-
Seth said the opposite.
Seth said it required a knowing, Seth said that there was a knowing withholding because the attorney failed to file it. The Tracy case is the one where the attorney had died and they found the will in the attorney's possessions after his death.
Well, Seth said the reference in the second sentence must be to a will described by the first sentence, i.e. a will that has been knowingly withheld from probate. Mm-hmm. And that is Chief Judge Green's position in the dissent in this case.
Right. And the Tracy case then said no, the such sentence, the second sentence, is an exception, and that such isn't limited to the cases that are only knowingly withheld, but also those cases that are negligently withheld or not filed with it.
And 2 of the judges on the Tracy case are the
We're
2
also on our
judges
case.
in the majority in this case.
Right.
Right. Sorry, did you have another question, Justice Luby? Any more questions of counsel? Thank you, counsel.
Thank you very much.
May it please the court. John McNish on behalf of Eric Strader. I just want to take a few minutes to convey Mr. Strader's perspective in this. It's worrisome to him that the emphasis is on a finding of fault, not on innocent beneficiary. Mr. Strader is truly an innocent beneficiary in that he did everything he was supposed to do. He went to the attorney's office and asked about the will. And I'd like to address one of the prior questions. That law firm had a practice of keeping wills. And so any original will that they kept, which they do routinely, would be kept in this office area in the middle of their office. So no action was taken to go back and look. Now, the other question was, well, how can you be sure there's not another 96 will? Well, as I appreciate the testimony, family dynamics were changing. And mother was attempting to address the change in those family dynamics, but couldn't make up her mind. The same firm who drafted the original, and I called it mutual will because they're mirror images, was the same firm working on her case, trying to address these changing family dynamics. The change was one daughter became estranged, one son basically took over the business. Those dynamics were in play. Now, the firm had a practice of keeping original wills. If there is another original will, it would be with their pile of original wills. So, having brought forward the only original they have would tell me, the inference would be there's no other will possible. I would also like to just address on the Seth case just a moment about the court did find that Mr. McCunt knowingly withheld. But you read the facts, you just marvel, did he know what he's doing? So we're really making a constructive argument that he did something bad. Was he there to harm somebody? I don't think Mr. Clinton intended. I don't think he knew what he's doing. Procrastination, whatever, he just couldn't get the job done. But the court didn't punish the innocent victim. One more thing.
Let's just say that the 96 will does exist and happens to turn up now, and it excludes your client. Would you be sitting here arguing that 96 will is effective?
Obviously,
I mean, let's just say that happens. I mean,
up.
you said there's some family dynamics that were occurring, and it's reflecting that family dynamic of the moment that maybe she was upset with your client. I don't want to, but let's just say that happened.
I think that was the exhibit, and I don't think that was the case. But
let's just say that happens. Wouldn't your argument say that 96 will is effective?
So the attorney law firm failed to find it, failed to produce it. All the facts are the same except it's a 96 will. I wouldn't be here. The 96 will be probated.
What's that?
The 96 will be probated.
And let's say the will's somewhere else, not in the attorney's office, but is found somewhere else. And how do we distinguish that?
Well, can I just kind of throw some facts at you? Mrs. Schrader.
You don't need to do that. I'm just wondering if you're just arguing that there's no evidence of a subsequent will, and if there is one, what happens then? Is my question.
Right. Well, you have two wills. We have to see. You have to go through the hearing process, which is the correct will, who did what will, and if that's the will, and the original will, the 85 will is not destroyed, well, the controlling will be the last will in time. And that will be probated. That's the way. Now, let's say she lived out in the country, maybe a tornado, let's say a tornado hit her home, and it scattered everything out, and they couldn't find that will. And they do the intestate, and then they find the will in the middle of a field. I think it's too late. Property sold, there's no reason to probate the will, it's lost. Nobody at fault here. No reason to punish somebody. That's just the nature of what happened. Here it's a totally different scenario. And I think what elevates it more is the attorney involvement. Yeah, with the attorney playing a role in this, it really makes it a heightened scrutiny type of case. It's just regrettable that it was lost in that firm. I use the term lost, but if he'd just gone and asked his secretary, where do we keep our wills? Can you go look? We're done. He'd gone to his senior partner. Where's our wills? Back here. Or just got off his duff and went back and looked. Because he's the one that found the other will. He was in there looking around. So why didn't he do it? I can't explain. My client would obviously suggest otherwise, but we can't prove those motives. But one final point is about Judge Jackson's ruling. And I have the transcript and I have the order. He was not saying that the attorney, nobody withheld, no one withheld. He was saying, given the state of law as he read it, the cases that we just argued today, he didn't have to make that finding. And I took it that Mr. Sprouse, the drafter, and him were classmates, and he wasn't inclined to make such a finding. And it wasn't necessary. The law is pretty, looking at those cases, there's really no reason for not probating this will. That's all.
So what finding was necessary in order to get this done if he didn't have to make a finding of knowingly withheld?
I think capacity was necessary, and we laid out the elements for the capacity for her to do that, and the fact of how it was lost and why it was lost.
So what exception was relied upon by the judge to get around the timing requirement of 617?
I think he looked at that second part of the statute with knowing withheld as a punitive statute. You're going to look to punish somebody. He felt that we didn't have to look at the second part of the statute because he's not there to punish anybody. The prior cases suggest we don't look no further. We just go with why and how and when, and not worry about finding a fault.
So you don't think you have to determine if the beneficiary was innocent?
That's a different story, yes. The beneficiary, in my case, Eric Streeter, purely innocent, truly innocent, did everything he's supposed to do. Went to the bank, went to the attorney's office, went to the home, did everything we were supposed to do.
So you think Judge Jackson's ruling that he was an innocent beneficiary is at least implied in his ruling?
Absolutely. I think it's required.
Okay. And what is your position about a plain reading of the second sentence? Do you agree with Mr. Troop's arguments on that?
I think when you make legislation sausage, I think they just crammed everything together without really thinking about the long run. They're trying to address a situation and not think of these hypotheticals. I think it was intended to try to punish the wrongdoer. And the purpose, I think that statute is trying to convey what Harper is saying. If you do a will, you got a right to probate. That's what we do wills for, have it probated. And so let's not get hung up on the wrongdoer. Let's try to protect the innocent party and see if he really is innocent.
Did the legislature accomplish that intent, though, with the plain language?
I don't think so. I don't think Mr. Troop's argument really is on point here because it just flies in the face of these prior rulings, especially the Harper case where they made it's a family settlement agreement they didn't refuse to allow. It just flies in the face of the Harper case where they're trying to have this will probated. And if you do a will, we honor the which is the deceased. And we bring that to the court. We're obligated to do that.
Any further questions? Thank you, counsel.
Thank you.
You reserve 3 minutes for rebuttal.
Yes, may it please the court. Had I known the entire focus of the appeal was going to be changed, I would have asked for more than 3 minutes. I had been focusing on the second sentence of 59-618 because I thought the first sentence was really out of the case by the finding of the district court, where the court further finds that no person knowingly withheld the will from probate. That's in his findings. Incidentally, that journal entry was prepared by Mr. McNish, so if he's arguing that it's contrary to what the transcript shows, then he's got some explaining to do there. But then even the Court of Appeals opinion says the court also made an express finding that no one knowingly withheld Betty's will from probate, and the Court of Appeals agreed with that finding. These guys never appealed from those factual findings. They didn't file a petition for review from the Court of Appeals finding that there was no knowing withholding here, and yet now they're arguing that, well, let's look at the first sentence of 59-618 and whether really there was a knowing withholding here. And as I understand it, they're saying Mr. Brenniger, and I don't think Mr. Brenniger was even around. I don't think he was in that office at the time this will got put away. So who is the person they are alleging knowingly withheld this will? Mr. Sprouse, who wrote it and then took the bench and retired and left the office, but maybe he was the one that left it, or a secretary, or what. But look at the first sentence of 59-618. The first part of it is in the disjunctive. Any person who has possession of the will of a testator dying a resident of the state, and that would arguably be someone in the law firm. I'll agree with that part, that they had possession. They didn't know it, but they had possession. Or has knowledge of such will and access to it for the purpose of probate. That I don't think there's any evidence showing that anyone in the office had knowledge of it. So that's the disjunctive. That describes the person, and knowingly withholds it from the district court having jurisdiction of probate. To me, withholding is knowingly withhold is almost redundant. I'm not sure how you unknowingly withhold something. If it had said, instead of knowingly withholds, if the statute said any person who has possession of the will of the testator dying a resident of the state and fails to deliver it to the district court, then maybe you've got an innocent or even negligent situation, that I had the will, I didn't know I had it, but I didn't deliver it, so maybe then that's met.
But
how is there knowing withholding here?
But the first part is not conjunctive. I mean, isn't it different if it's possession and has knowledge? Doesn't that, wouldn't that, I mean, if they had used and instead of or, it would very clearly have told us that the person must be aware they have possession.
The description of the person is in the disjunctive. It's either a person, because there's an or there, either a person who has possession of the will, or a person who has knowledge of the such will and access to it. And somebody in a law firm could fall in that first part. They had possession of it. They didn't know it, but they had possession. But then it's conjunctive, and that person in the first part of that clause knowingly withholds it from the district court. That person who didn't know they had it can't knowingly withhold it. But
then what's the purpose? I think Justice is asking you, what's the purpose of including possession if it only applies to the second part of that disjunctive, knowledge and access?
No, I think either a person falling in either of the first two categories, either possession or knowledge, but obviously because of the conjunctive part of that sentence, the knowingly withholding, that makes it impossible for...
Well, that renders superfluous and meaningless the have possession of.
I agree. That possession has to be knowing. You can't knowingly withhold it unless you know you got it.
And part of our construction rules are that we don't construe a statute to render it meaningless or superfluous.
Right. I think combining those, because I agree, I don't think you can not know you have it but knowingly withhold it.
So or really means and in this case. Knowingly means knowingly, but or means and.
Well, I do think, because of the second half of that sentence, I do think the person who has possession has to know they have possession. I think that much is implied. But that doesn't mean it's superfluous, because the second part of it broadens that and applies to a person who may not actually have possession of it, but say, I know that I left the original will in my lawyer's office. I don't have possession of it, but I got knowledge of it and I got access to it because I can go to my lawyer and say, give me the will, or go to the scrivener. So I don't think it's superfluous, but clearly that says knowing withholding. And Mr. Knopp's argument about, gee, we got an agricultural legislature, they've had 70 years to address this. In re Parada was decided in 1941, that was a lost will case. If they wanted to say, hey, we want to create an exception for lost wills, why didn't they do something after in re Parada? Even farmers who only come to Topeka for 90 days a year, somebody in those 70 years, some lawyer who was dissatisfied by a result, surely could have gone to their legislator and said, hey, change this. This is unfair. It didn't happen. So we think this factual thing that they've thrown up now about, gee, was there knowingly withholding or not? It's too late for that. I don't think here is the time to raise, we don't agree with the factual finding that the district court made, the Court of Appeals approved, and we haven't appealed from. The facts are over in this case, and the decision is, do we remand it with directions to proceed to administer an intestate estate, or do we affirm the decision? And I think it gets remanded for an intestate estate. Thank you, Your Honor.
Do we have any more questions? Thank you, counsel. Thank all of you for your arguments this morning. Court will take this matter under advisement.